Hey everybody, this is Mr. Moppin coming at you with another AP Gov video. This is our third and final video on topic 3.11, focusing in on government responses to social movements. Last time we were here, we were talking about the existence of Jim Crow segregation that was constitutionally protected in the South for many decades until the beginning of the end of that with the ruling in the case of Brown versus Board of Education, which eliminated separate but equal as it pertained to public education. We also talked about how by the 1960s there was now true full-throated support for civil rights legislation coming from the White House, first with Kennedy and then more importantly with President Lyndon Johnson. Now, due to Lyndon Johnson's connections with Southerners, him being a Southerner, and his longtime experience in politics, including being the Senate Majority Leader for a time, we're going to be able to see President Johnson get civil rights legislation across the finish line with the passage of the Civil Rights Act of 1964. Now note, even though Congress and the President put this into law, this is only coming after many, many years of organized civil rights activism coming from leaders like Dr. Martin Luther King Jr., including the use of things like boycotts and sit-ins and protest rallies and things like that to put, tremendous pressure on governments via media attention to address this issue once and for all. Now, with the passage of the Civil Rights Act of 1964, what this is going to be doing is ending what we call de jure segregation in public places. In other words, the elimination of segregation by law in public places. Now, obviously, laws do not change customs and traditions overnight. It certainly does not change mindsets overnight. But at least on paper, you can no longer legally segregate people with regards to public facilities like restrooms or restaurant access to a theater or something along those lines. That is abolished forever. It also protects protects against discrimination in terms of hiring, that you cannot deny someone a job on account of race or ethnic background. This is going to be particularly important in terms of enforcement. To enforce the hiring protection piece, we're going to see the creation of something called the EEOC, the Equal Employment Opportunity Commission. And basically what this does is put in place a mechanism where if you are someone that is of a minority status and you are applying for a job or promotion, something along those lines, and you feel that you've been denied that job due to your minority status, you can, file a lawsuit through the EEOC where the federal government will be helping you in your attempts to try to gain justice in that situation. So in many respects, you can see that the federal government's serious about this, that the federal government is not just on paper wanting to promote civil rights, but actually putting in mechanisms to properly enforce those policies. Now, once again, just because you now have civil rights protections on paper, and it's going to be on paper changing the South forever, it doesn't mean that it's going to be accepted by racists in the South overnight. And almost immediately, you're going to see a lawsuit challenging the constitutionality of the Civil Rights Act. And note that the argument is that the federal government had the authority to create the Civil Rights Act as a power vested within the Commerce Clause. Remember, the federal government, per Article 1, has the ability to regulate interstate commerce. And the Civil Rights Act will survive this constitutional challenge in the case of Heart of Atlanta Motel versus U.S. So the idea being is that, yes, this is constitutional, the Civil Rights Act of 64. Yes, it is vested in the Commerce Clause because the basic gist is that, if you are engaging in business, at some point in some way, you're going to be engaging in interstate commerce. It doesn't matter, if you just own a single motel location in one state. You're going to be getting, visitors from outside the state. You're going to be getting supplies brought in, like toilet paper or, silverware or bedding or whatever, towels coming from outside the state. And so as soon as you cross state lines in any way, shape, or form as in any part of your business, then that's now interstate commerce, which now the federal government has the ability to regulate. In other words, now the federal government can mandate that your motel, for example, cannot deny customers on account of their ethnicity. So that's going to be an important protection. Now, something else that's important to know with regards to the Civil Rights Act is that it doesn't just protect from discrimination on account of race or ethnicity, but also religion and also sex. This is going to be pretty interesting. Excuse me. That these applications also apply to sex, which is going to be particularly important. This will be the foundation for what will be an amendment to the Civil Rights Act in 1972 called Title IX, which will expressly forbid discrimination in terms of education by high schools, elementary schools, universities with regards to federal funding. So, bottom line, if you want to receive any federal funding from the government for your school, you cannot be engaging in gender discrimination. And it's not just in academics, all right? We're also talking about athletics and the fact today that we have, scholarship athletes for women is because of Title IX. The fact that, women have an unencumbered opportunity to take physics and calculus classes or to take, career-based courses that tended to be skewed towards men, for example, like auto shop and welding. That's because of Title IX, and that's because of the Civil Rights Act of 1964. Note, the importance of the Civil Rights Act of 1964 does not just extend to those that are explicitly protected under the legislation, like people of color and religious minorities and women, but it served as an inspiration for other minority groups also seeking that same equality under the law. Like, for example, those that are physically or mentally disabled, those that are part of the LGBTQ community, etc. So in many respects, this has had a mammoth effect on, redefining what equality really means in America. But despite all of the importance of the Civil Rights Act, it does not include one particular protection. It does not provide explicit protection with regards to voting. And this was still a challenge for Black Americans in the South that were still grappling with many of those traditional blocks. Finally, in 1963, the Constitution had to be amended by the 24th Amendment to ban poll taxes, which is good. It's an important success. But still, though, you had things like literacy tests that were still on the books. And so if you were black in many southern states, you still, in many respects, did not have a realistic opportunity to vote. And so you're going to see civil rights activists, like SNCC and others, begin to, push this idea that these states have to change, and these states are not going to change without federal enforcement. This is going to lead to one of the more infamous protest marches, and that is the march going from Selma to Montgomery. That is going to be known as Bloody Sunday in 1965, and it's going to be earning that moniker, as you can see here, due to the fact that, like so many other civil rights protest marches, this was done in a nonviolent way. Local authorities, as we had seen in Birmingham a couple of years earlier, will tell these protesters that they had to disperse their march, they had to go home, they had to end the march, and when they would not do that, engaging in nonviolent passive resistance, the authorities will respond with brutal violence. As you can see pictured here, folks that are going to be beaten with billy clubs, tear gas, etc. When this is broadcast across the country in the media, the nation is going to be aghast. It is going to be embarrassed that these kinds of brutal tactics are going to be used to thwart any attempts, peaceful attempts, to try to gain the most basic of rights that people should be able to enjoy, and that's the right to vote. Inspired because of this continued nonviolent protest movement, we're going to be seeing shortly afterwards the passage of the Voting Rights Act of 1965. And what this does is specifically ban attempts to limit voting like literacy tests. Grandfather clauses had already been gone because of over time. Black Americans no longer had grandparents that were slaves, so that was not applicable anymore. But this does ban things, like white primaries. It does ban literacy tests, and as I already said, the 24th Amendment already abolished poll taxes. It also puts in place the mechanism for federal enforcement of this law, and that's going to be important. We know that voting is a state power. It's part of the 10th Amendment. But the concern is that, can you trust these southern states that had a history of Jim Crow segregation, had a history of trying to find any and all means to keep black Americans in reality from voting? Could you trust them to, be able to enforce this? And the answer was no. And so what the Voting Rights Act of 65 does is, in many respects, strip a lot of the power that these southern Jim Crow states had with regards to making or modifying voting policies. It put in place that if you were a Jim Crow state historically, like say Alabama, and you wanted to change your voting laws, they had to be approved by the Justice Department, federal government. And so that's going to be very important to make sure that this protection is not just on paper, but put in as a reality. Now, that being said, that protection in terms of federal enforcement is no longer in place. We saw in a more modern Supreme Court ruling that after 50 years of the Voting Rights Act in place, there was a sense by the Supreme Court that southern states had been able to prove that racism is now is not now so entrenched that southern states can't be trusted with making their own voting laws without federal approval anymore. So that mechanism has been stripped away. So southern states can once again make their own independent decisions with regards to voting as long as it is in line with the Constitution. Okay? But anyhow, very important milestones in the fight for civil rights, Civil Rights Act and Voting Rights Act. Okay? All right, we'll see you next time. Bye-bye.